I sat down with Washington State's Chief Privacy Officer, Alben. He touched on a lot of things, but one of the first things he brought up was the current encryption battle of Apple versus the FBI. Here's what he had to say.
Well, thanks so much, Alex, for coming to Penta today. We really appreciate it here. Kind of first, just to tell the audience a little bit about your job as the Chief Privacy Officer for Washington State, and a little bit about your background.
So, Carly, this job started in April of last year. Governor Inslee appointed me, and I'm the first person to be a Chief Privacy Officer for the state of Washington. We like to think of ourselves as leaders in technology in the state of Washington. I think there are 2 or maybe 3 other states that have a Chief Privacy Officer. So we need to keep and store that data, and we need to keep it safe. We live in an environment of increasing cyber threat. So there are attacks on our networks all the time. And so that is a 24/7 job of keeping the data safe. In response to that, Apple and the other tech companies as well have put more secure encryption around the devices that they sell. So in the case of the iPhone, Apple instituted encryption so that the government could not break into or intercept the communication. So this creates this tension where, on the one hand, law enforcement wants to look at an iPhone or actually a lot of different conversations, and the company representing consumers says, these are really private conversations, that what they say on their iPhone and what they text on their iPhone or other methods such as FaceTime, that those are going to be private and that the government is not going to be able to access them. So that's the conflict. And conflicts are usually resolved in our country in courts. And as you know, the FBI has brought an action to compel the breaking of the encryption around the iPhone, in this case that was used by one of the terrorists in San Bernardino.
You touched on a lot of different things there. So I know you talked, one of the things you mentioned was the Patriot Act. The FBI's precedence is the All Writs Act, which was a law that created like 300 years ago, and it's basically saying they have permission to tap into the iPhone. And I know we were kind of talking to a little bit about how, I know that in your book you talk a lot about how our technology, and with technological advances, we don't really necessarily have laws that appropriately address that. Could you expound on that?
So one of the laws that was drafted in the 1780s was called the All Writs Act, and it was basically meant to give courts the power to enforce laws that were already on the books, things they needed to do. So when the FBI is trying to say that they have the right to compel a court to open this iPhone, they are citing the All Writs Act. Now, in 1789, or close to when this was adopted, we didn't have telephones or modern communications. So it's a little bit of a stretch to say that maybe the founding fathers were thinking that this All Writs Act would apply to an iPhone. Or even the principle, actually, that the courts can go into individual cases. So in the law, what we say is when there is an established regime to administer something, the All Writs Act should not be used. The principles involved from the 1700s, and even in the case of Washington State was founded in 1889. And privacy is actually written into the Constitution of Washington State. They put it in the rights section, and the phrase is that no person shall be disturbed in his private affairs. And actually what they were thinking of at the time were modern communications like the telegraph. So they were already anticipating that what was meant by private affairs was going to change over time. So it's nice to have these protections, but we also need people who can interpret the law and make these